Welcome, members and guests. Today is Tuesday, March the 22nd, 2022. I hereby call the Civil Justice Subcommittee to order. Ms. TJ, please take the roll.
Representatives Clemens. Here. Curcio.
Here.
Farmer. Here. Garrett. Yep. Griffey. Ogles.
Here.
Parkinson. Ramsey. Chairman Russell.
Here.
Chairman, you have a quorum.
All right, members, we're going to try to go through this calendar pretty quick. We'll have to take a couple bills out of order. Chairman Curcio may have to step out for a few minutes. So first up, item number 8, 2538. Do we have a motion? We got a motion. We got a second? We got a second. And Chairman Curcio, I'll show an amendment. Do you have an amendment you'd like to run with?
Yes, sir. I'd like to move Amendment 15648.
Okay, I'm showing that's correct. You're recognized on the amendment. We do have a motion and a second.
Thank you, Mr. Chairman and committee members. This bill is actually kind of a companion bill to the next bill that I'll be bringing up, but it deals with qualifications for judges to run for office. We just want to make sure that these folks have the utmost character and standing in the community. So with that, I renew my motion.
Any questions? Representative Clemens.
Thank you, Mr. Chairman. I'm trying to get the catch up here. We're on number 8, right?
We are. We're still on the amendment.
So my concern with this bill, I just had questions. Would this go into effect now?
Chairman Curcio.
Thank you, Mr. Chairman. The enacting clause in Section 2 is upon becoming law.
Chairman, Representative Clemens.
This takes effect upon becoming law. So we've got a bunch of people out there that have already qualified to run for judge, and we're changing the rules midstream. That's concerning to me. And does this apply to sitting judges who are running for re-election?
Chairman Curcio.
Thank you, Mr. Chairman. No, it's what we're trying to do is make sure that folks getting on the ballot moving forward adhere to these.
Representative Clemens.
Would the sponsor be willing to push this effective date in Section 2 until July 1st when most of these things go into effect? Because current candidates on the ballot right now have probably expended a great deal of money. I know one of our colleagues is running for office. This doesn't affect him, I'm sure, but I think you change the rules on somebody midstream after they've spent the money, they've gotten their petition filed, and here we are, a week or so from election. That's pretty unfair. If somebody did that to us, I think we'd be raising Cain about it. Do you have any response to that?
Chairman Curcio.
Thank you, Mr. Chairman. Yes, sir, I do. If I had been engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation, I would hope they wouldn't let me on the ballot.
Representative Clemens.
Yeah, I certainly understand that, and I have no problem with that. I'm really trying to get at the intent of this, and if we have judges sitting on the bench who would fall into this category, and this doesn't pertain to them, but now we're changing this midstream, it seems to me, if you're just opening up, I guess it's Rule 8, which sure. could encompass any of this, from my understanding, it might raise some concerns. But hey, it seems like it's flying through. I just think it's unfair to change the game on candidates midstream. Well, that's it. Thanks, Mr. Chairman.
Thank you, Representative Clemens. And we got the question on the amendment. We're voting to add Amendment 15648 to House Bill 2538. All those in favor signify by saying aye.
Aye.
Opposed, no. Amendment added. Okay, Representative Ogles.
Thank you, Chairman, and to the sponsor. Does this require criminal prosecution and a conviction, or is this simply a censure based on possibly a complaint by a constituent or somebody? Is this purely? And the only reason I ask this is it seems like every couple of years I have commercials go on TV where my judges are accused of all kinds of wrongdoing and being lizard people and doing. I mean, it's all over the board. And not to make light of that, but can you explain a little bit more specifically what this entails? Thank you.
Chairman Curcio.
Thank you, Mr. Chairman. Yes, no, that's a great question. So Item number 3, under Section 1A, so 3, not having been publicly censured or suspended or disbarred from the practice of law by the Board of Professional Responsibility within the 10 years preceding the judge's term of office. So this would not disqualify you from practicing law. We're just saying that we want our judges to have a higher standard of moral turpitude. And again, they're not barred from becoming judges forever. So it's this kind of 10-year timeout period if they've been publicly censured or suspended or disbarred from the practice of law by the Board of Professional Responsibility. And again, that's for conduct involving dishonesty, fraud, deceit, or misrepresentation. So this is not just somebody accused me of something. This is I've gone through a vetting process and I've been found to be insufficient in this way.
Representative Ogles.
Thank you. I'm just a little concerned that if there's enough evidence to be publicly censured, I would hope there would be enough evidence for criminal charges. But that's just. But I think you proved the point, and I support this piece of legislation. Thank you, sponsor.
Thank you. Chairman Curcio, you have a follow-up?
Yep.
Chairman Farmer, you recognize.
And members, as I listen to this, it reminds me of how the board's changed over the years. I remember when I first came in, I believe they started the CAP program. It's the Consumer Assistance Program, CAP. So probably 99%, 95% of the complaints that come in go through CAP. And it's just this entry-level department that the board created, which was brilliant, that handles those small, hey, he did this lawyer did this, yada, yada, yada. 95+% of claims is handled in CAP. If it goes from there, then it moves up to the disciplinary council, right? Then we're talking about maybe a private admonishment. Then you have a public admonishment. Then you have a private censure. Then you have a public censure. And this is what we're talking about. So we're 4 levels up now into the public world realm of what's called a censure. Then next you move into suspension. So it's not just like, hey, my lawyer, burnt the gravy here. I can't run for judge now. That's not what we're talking about. We're talking about 4 or 5 layers up the chain. We're talking about into the disciplinary counsel's office of the Tennessee Board of Professional Responsibility for those items, as Chairman Curcio spoke of fraud and dishonesty and those things that are unbecoming of an attorney, let alone a judge. So I just wanted to make that clear.
Thank you, Chairman Farmer. And Representative Clemens, you're recognized.
Yeah, thank you, Mr. Chairman. And I am in agreement with the comments of Chairman Farmer. This is public censure is one of those things we wake up sweating in the middle of the night about, even when you don't have a deadline or something like that. For us attorneys, it's kind of a worst nightmare scenario, and anything worse than that, especially. And so I agree with the spirit of this legislation. My question is, if we want to make sure that the judicial candidates in this state are of the utmost integrity and, that level we would like for our judiciary to be at. My question is it possible for a judge to get convicted of a DUI and still qualify the ballot, but be publicly censured and not qualify? And if so, why aren't we going that far with this to protect the integrity of the judiciary?
Chairman Curcio.
Thank you, Mr. Chairman. I think that's an excellent suggestion, and if you were to bring a piece of legislation that would consider that, I'd certainly consider supporting it.
Representative Clemens.
Okay, that's just a question I had, because if we're really going to look at protecting the judiciary and changing this thing midstream on candidates, we might as well go all the way. So I guess we'll have to look at amendments. Thank you, Mr. Chairman.
Thank you. And not seeing any other questions, we're voting to send House Bill 2538 to civil full. Representative Parkinson.
Thank you, Mr. Chair, for the indulgence. With this bill, those that are on the bench now that have been censored. Okay, thank you.
Chairman Curcio, would you like to respond?
No, it takes effect upon becoming law.
Representative Ogles.
Thank you, Chairman. To the sponsor, I think there was another piece of legislation that went through a committee that was dealing with elections and qualification for the ballot. And I think there was some discussion with the lawyers about the constitutionality of enacting a law so close to the filing deadline. Is there any issues with this piece of legislation as far as the enacting date that we're worried about, as far as throwing people off the ballot potentially at this 11th hour?
Chairman Curcio.
Thank you, Mr. Chairman. To my good friend from Williamson County, I think I hold the sole distinction of voting against one of my own bills in the well of the House because of a constitutional question. So no, I don't think there's anything constitutionally suspect about this.
Question been called. We're voting to send House Bill 2538 to civil full. All those in favor signify by saying aye.
Aye.
Opposed, no. Ayes have it. Congratulations, civil full. Next up, item number 9, House Bill 2401 by Chairman Curcio. We got a motion. We have a second.
Thank you, Mr. Chairman and committee. I would like to move amendment coded 15719.
That's what I'm showing. We have a motion on the amendment. We got a motion.
Second.
We got a second. We got a second. And you're recognized on amendment 15719.
Thank you, Mr. Chairman and committee. And again, these two bills, I really kind of see them as companion bills. But a couple years back, Chairman Bell over in the Senate and I reconstituted the Board of Judicial Conduct. This is another step in making sure that our judges are held to the highest standard. And it would, in short, expand the jurisdiction of the Board of Judicial Conduct to all elected judges. So if you've got the power of a judge and you're elected, then we want you to be subject to the Board of Judicial Conduct.
Thank you. And we're going to vote to add amendment 15719 to House Bill 2401. All those in favor signify by saying aye.
Aye.
Opposed, no. Amendments added. Any questions for the sponsor? Seeing none, we're going to, okay, Representative Clemens.
Thank you, Mr. Chairman. Mr. Curcio, can you explain what changes this makes to the current process?
Chairman Curcio.
Thank you, Mr. Chairman. So it expands who is subject to the Board of Judicial Conduct. So it doesn't change anything about the board itself. It just expands it to anybody who's got judicial authority who's elected.
Representative Clemens.
Does it make any changes to the process itself about making a complaint or following up on that complaint?
Chairman Curcio.
It's my understanding that it does not.
Representative Clemens.
I didn't hear his answer. What was it?
Chairman Curcio.
It's my understanding that it does not.
Can we go out of session, Mr. Chairman, and ask legal for clarification?
All right. Without objection, we'll go out of session and recognize legal.
Michelle Fogarty, Legal Services. It adds that the board may investigate an active judge suffering from a temporary or permanent disability, physical or mental, whereas current law says likely to become permanent. And it also defines temporary or permanent disability to include substance abuse or dependency, repeated or consistent inability to stay alert during court proceedings, impairment of cognitive abilities that render the judge unable to function effectively, and any other documented or diagnosed physical or mental behavioral condition adversely affecting the administration of justice. It also allows referral to the Tennessee Lawyers Assistance Program. And it states that a complaint must be filed within 1 year of the time the party filing the complaint knew or reasonably should have known of the alleged misconduct.
Representative Clemens.
Thank you, Mr. Chairman. And with those additional grounds to file a complaint, does the process of review or the standard of review before removal change at all because of this legislation?
Legal, you're recognized.
It does not amend that section, 175307. It does not amend that section.
Representative Clemens.
Thank you. I appreciate that clarification. Thank you, Mr. Chairman.
All right. We'll go back in session.
Thank you, Mr. Chairman. And to my friend from Davidson County, I apologize. I thought you were asking me the second question that you asked legal, which was, does it change the standard? So I apologize for not answering your question fully.
Representative Clemens, you have any follow-up? All right. We're voting to send House Bill 2401 to civil full. All those in favor signify by saying aye.
Aye.
Opposed, no. Ayes prevail. Civil full. That brings us to the top of the calendar, item number 1, 2438 by Chairman Farmer. Do we have a motion? We got a motion, and we have a second. Chairman Farmer, you're recognized on House Bill 2438.
Thank you, members, and Mr. Chairman. This bill was brought to me by the Tennessee Bar Association. What this does, it revised the revised Uniform Arbitration Act It's an update, and this is what this is, the revised Uniform Arbitration Act. It's an update to the Uniform Arbitration Act that is currently in place in Tennessee. It's here to bring it in line with current needs and to address procedural issues not included in the original Uniform Act. Not that this matters for us because we do what's good for Tennessee, but 22 other states have adopted this act. It was promulgated by the Uniform Law Commission, and the bill was fully vetted by the Tennessee Bar Association's Dispute Resolution Law Section. With that, I'd move passage. I'd be happy to take any questions you all may have.
Thank you, Chairman Farmer. And just to clarify, this does make various revisions to the Uniform Arbitration Act. Representative Clemens, you're recognized. You're recognized.
Thank you, Mr. Chairman. So my single question is, arbitration clauses are sometimes the bane of my existence in contract disputes. Does this force arbitration clauses in any way greater or affect the law with regards to enforcement of those arbitration clauses, or does it just merely address the process itself?
Chairman Farmer.
As I understand it, I'm looking at the fiscal note, and it says, according to the administrative office of the courts, the proposed legislation is not expected to increase the number of filings. So I wouldn't think it would compel or force anyone into any additional arbitration. So, and it's a pretty lengthy piece of legislation, but as I look at it, it looks like it surrounds more of the procedures on how things are done. Maybe clarifies what, just the rules there. So I guess the latter of your thoughts is correct there.
Representative Clemens.
Okay, thank you, Mr. Chairman. Thank you, sponsor.
Thank you. We're voting Representative Ogles.
To the sponsor, what act does this amend again?
Chairman Farmer.
The Uniform Arbitration Act.
Thank you, Chairman.
All right. Question's been called. We're voting Senate House Bill 2438 to civil full. All those in favor signify by saying aye. Opposed, no. Ayes have it. Civil full. Next up, item number 2, 2554 by Representative Hurt. Do I have a motion? Do I have a motion? Second. We got a motion and a second. Representative Hurt, do you want to run your amendment?
No, sir, Mr. Chair.
Okay, you're recognized on the bill.
Thank you, Mr. Chair and Committee. I appreciate the opportunity to speak briefly on this, on House Bill 2554. In Tennessee, the Supreme Court has ruled that off-duty police officers are basically equal to citizens. The off-duty officers may assume official duties and exercise full police power while off-duty if they know or have reason to suspect any person of being armed with the intention of committing a riot or affray, or of assaulting, wounding, or killing another person, or of otherwise breaking the peace, to arrest such person forthwith and take such person before the Court of General Sessions. But police officers in Tennessee do not possess the exclusive authority to make arrests, as private citizens possess this power in many of the same circumstances as I just named as officers on official duty. TCA 47-109. With that being said, and off-duty police officers being ruled as basically equal to citizens, there are still places that off-duty officers can carry that normal citizens cannot. The goal of this legislation was to allow enhanced carry permit holders to carry in places off-duty officers can. But after visiting with many of the committee members, I understand there are still concerns with the bill as written. And with that said, Mr. Chair, I will take the bill off notice.
Without objection, off notice. And thank you, Representative Hurt. Thank you. Next up, item number 3 by Chairman Kumar. No. Well, he's not here, so we'll roll this bill to the hill. Next up, item number 4 by Representative Cooper, House Bill 2350. We got a motion and a second. Representative Cooper, you are recognized, and I do show an amendment. We got a motion and a second on the amendment. And Representative Cooper? And we do show that. Is you have a drafting code for us?
I didn't understand you.
Do you have a drafting code for your amendment?
I have amendment 011037.
That's not what I'm showing. I'm showing 015456.
And I have that 015456. I have that.
That's correct. Do we have a motion and a second on the amendment? We do have a motion and a second. Chairman, Representative Cooper, you're recognized.
Thank you, Mr. Chair. House Bill 2350 is intended to have judges recuse themselves from a case if there is any semblance of the lack of neutrality. And the fiscal note is non-significant. And I have Attorney Larry Parrish here, a constituent who brought the bill, and would like to explain and ask any questions, Mr. Chair, and I appreciate your permission for him to speak.
Thank you, Representative Cooper, and we'll go out of session and hear from Attorney Larry Parrish. Mr. Parrish, if you'll come up to the table there, turn your little red light on, you'll have 3 minutes, and just identify yourself to the committee. Begin when you're ready.
Yes, Your Honor. Thank you. I appreciate it.
And pull the microphone just a little bit towards you there, and make sure that little red button's on down there.
And am I on?
I don't think so.
Okay. All right. Thank you. Yes, I appreciate the opportunity to speak to you about this bill. I represent nobody. I'm here for Larry Parrish and the rest of the citizens of Tennessee. I come as a person who's been practicing law for 55 years. I'm in my 55th year, and there has not been a day in that 55 years, including the day that I got my heart surgery, that I was not practicing law. And I'm a litigator primarily. I practice all over the United States. I've had cases in 15 different states, I guess. I've got one now I got 2 in New York City and several in Tennessee. So, and I was a federal prosecutor for 10 years in Memphis and had cases all over the United States as a federal prosecutor. So I come knowing of which I speak, and that's being in the courtroom. At this point, I've been practicing so long that I'm old enough. The Tennessee Bar Association acknowledged me as one of the oldest continuously practicing lawyers in Tennessee, so most of the judges are younger than I am now. And most of them did not see what I saw. I have watched a transition. I know how it used to be and how it ought to be, and I see how it is now. And so I come talking about result-oriented adjudication. I hope that becomes a household word. I know it's not a household word right now, but I think most lawyers know what I speak of when I talk about result-oriented adjudication. And basically, it is a situation where judges decide what result they want to see in a case, and they formulate their opinion around the result. This is common practice at this point. This comes to you as totally nonpartisan. I am a longtime conservative, not moderate Republican who was a delegate to the convention that nominated Ronald Reagan. I've been on the steering committee in Shelby County and I've run for office as a Republican, et cetera. And the sponsors of this bill are Democrats and African American Democrats. And that just the point to be made by that is there's no partisanship here. It doesn't matter if you're liberal, you're conservative, what party you're in, what race you are, or anything else. Everybody deserves to have a neutral judge when they walk into a courtroom. And I think everybody would agree with that. And one of your members asked me as I was talking about this to him, and he said, give me an example, so I can see this in real life. And so at the time, I had a brief petition for certiorari I had just filed in the United States Supreme Court, and so I just gave him that case. But I want to give one before then. I want to give 2 examples.
Mr. Parrish, that's your 3 minutes. We'll have unlimited time for questions, though. Any questions for Mr. Parrish? Representative Parkinson, you're recognized.
Give me an example.
Mr. Parrish, you're recognized.
Involved a case in Texas, in Dallas, Texas. It's been 3 or 4 years ago now. My client literally spent tens and tens and tens of thousands of dollars. The law was absolutely clear. There was no question about what the law was. We came to the hearing for the decision on a motion that was being made. And the judge, a kind man indeed, and he looked at me and he said, Mr. Parrish, I agree with you that the law is exactly like you say it is, but it's just not fair. It's just not fair to have somebody be liable under these circumstances. He thought the statute of limitations was too long. He said it's changed now, but I'm sorry, I just can't do it. It's not fair, quote unquote. I cannot tell you the devastation that was to my client. I could go on. It's still on. The other one, and the one I gave to that question when I was asked before, is a case that is before the U.S. Supreme Court right now. And here is a case where it involves the revocable living trust. And I'm not here to say they're good or bad or not or anything. I do know there is a Tennessee case in 1987 that did not accept the revocable living trust. And so I went into probate court for clients who had been disinherited by one of these devices. And the judge was a person I've known for 17 years, friends, we're great. And so I didn't know, because I don't do that much trust and estate work, and so I didn't know that I was the bull walking into the china shop. And so I'm in there saying this revocable living trust is not legal according to a particular case from the Supreme Court. And the judge went livid, absolutely livid, because, as I found out, he had drafted, one person said probably 10,000 of these things. And essentially, I was asking him to decide what he's been doing for years is illegal. Well, that's fine for the judge. I don't have any disagreement. But why would he not recuse himself? I asked him to recuse himself, and he would not do it, and he became more and more inflamed. That's an example of result-oriented adjudication. And what it has done to those clients is absolutely, and I could give more examples. Okay, I answered the question, so I will wait for another if there is another.
Thank you, Mr. Parrish. Any other questions? Seeing none, we appreciate you being here today, and Representative Clemens.
Thank you. This is a tougher panel than the Sixth Circuit. Definitely more of us. Explain to me what differences this would make. I mean, we're abolishing recusal motions. And
Yes.
so the idea of neutrality is redefined in this legislation. The recusal motions are abolished. The process is rewritten. Explain exactly how this would work.
Yes, Your Honor.
As opposed today, and I'll take the Your Honor.
Okay.
I don't know if I'd win that
I'm
race,
just
but
so accustomed to saying Your Honor. Your
Parrish,
Honor,
you're
I
recognized.
can't get away from it. But, yes, and the reason for the abolishment of the recusal motion is that throws onto the litigant the burden of having to say to the judge, Judge, I think you should be disqualified. I think that Williams versus Pennsylvania, the recent U.S. Supreme Court case, throws that burden back on the judge. The judge knows his predispositions or her predispositions. He knows that he's a duck hunter, and this case is about whether duck hunting is illegal. And the judge should be responsible for withdrawing himself, not waiting to be for a litigant to have the problem. And now the way that it's set up, if you don't make it within a certain time, you waive it. So essentially, a litigant could miss a time deadline and would have waived his right to a neutral judge. And so this just throws it back to the judge. You say whether you should withdraw or not. And if you say not, then you sign a statement of no conflict or whatever, and then the litigant can object to that, and then it just lays there. Let's go on with the trial, and after the trial, it would become a matter of appeal, or because if a non-neutral judge makes a decision according to the United States Supreme Court in Williams versus Pennsylvania, that's not a decision. It is void as if the judge had no jurisdiction. So it can be, let's don't hold up the trial for months and that sort of thing. Let's just state your position. And I think the effect of that is it causes judges to stop and think and to realize this is a real serious issue, rather than get on the bench and hope nobody makes a timely recusal motion, which is a real pressure for a litigant anyway.
Representative Clements. Thank you. Any other questions for Mr. Parrish? Representative Ogles.
Thank you, Chairman, and thank you for being here today and your great testimony. Under this new system, would this not encourage, I'm just playing devil's advocate here, and if I was a lawyer and had something of substance, wouldn't it incentivize litigators to file that recusal motion just on hope that they're making a path for appeal later if something ever were to surface? Wouldn't you almost be compelled if you felt extremely emotional about the case, about the client, to almost be compelled to try to get the judge to recuse himself, or at least file that motion to recusal, or that new process you've entertained? Just your thoughts on that.
No.
Mr. Parrish, you're recognized.
Excuse me, I'm sorry. This would do the opposite, I think. Right now, the pressure is on a litigant to file a recusal motion or agree to being heard by a judge who may or may not be. In this process that this bill foresees, the first thing that happens is a judge must sign a statement that I have no predispositions that would give someone question about my neutrality. Now, if a litigant wanted to file an objection to that, the litigant has to do it under oath and have good reason and state your reason, and it's just filed. And it sits there for later use. The litigant cannot be said to have waived that, but the litigant better have some dadgum good reasons if he files it, because it's going to be something that has to be filed under oath.
Representative Ogles.
Thank you, Chairman. Thank you for that explanation.
Thank you.
Okay, I don't see any other questions. We appreciate you being here. Thank you for your service, and we'll go back in session.
Thank you.
And we are going to vote on putting Amendment 15456 onto House Bill 2350. All those in favor signify by saying aye. Opposed, no. Amendment's added. And Representative Cooper, you're recognized on 2350.
I was trying to remember the vote. What did you say? It failed or it passed?
We just added the amendment to the bill,
Oh.
so you're recognized on the bill as amended.
Thank you, Mr. Chair.
Thank you.
The amendment simply does what Attorney Parrish has said, and that is a judge must recuse himself if there's any semblance of lack of neutrality.
Thank you for that. Do we have any questions for Representative Cooper and Chairman Curcio?
Thank you, Mr. Chairman. And I want to thank Ms. Cooper. She brought this bill to me before session started, and we read through it. And I think, like a lot of things that we deal with in this committee, it's taking an existing process that's worked well for a long time, but it's envisioning a different way to do it. And I don't think there's anything wrong with that. I think it's a pretty significant rewrite of how this process works now. It's an 18-page bill coming up here on the closing day of this committee. And I just want to make sure that we do, because I think this has a lot of merit. There's a lot in here that needs to be discussed, but I think it's a lot to do this morning. And I know time is running short with this General Assembly. I'd like to make a motion to send this to summer study so that this can be fully vetted, and I want to see this fully fleshed out in the next General Assembly.
It's a proper motion and proper second. All those in favor for sending House Bill 2350 to summer study signify by saying aye.
Aye.
Opposed, no. Ayes have it. House Bill 2350 goes to summer study.
Thank you, Mr. Chair and members.
Thank you. Okay, we're going to reconsider our actions and go to item number 3, House Bill 2850 by Representative Kumar, Chairman Kumar. We've got a motion. Do we have a second? We've got a second. Representative Parkinson.
Mr. Chair, what's our process for reconsidering our actions?
We will need 6 members to vote in favor to allow Chairman Kumar to present today.
Okay, thank you, sir.
Thank you. And Representative Garrett?
Mr. Chairman, I'm make a motion to reconsider our actions on this particular legislation.
We've got a motion to reconsider action and a second. Okay, we're going to vote by roll call to reconsider our actions. And Ms. TJ, if you'll call the roll.
Representatives Clemens? Aye. Curcio?
Aye.
Farmer? Aye. Garrett? Aye. Griffey? Ogles? Aye. Parkinson? No. Ramsey? Aye. Chairman Russell?
Okay, Chairman Kumar, you've got, would you like to read the vote?
Yes, please. Clemens votes aye. Curcio, aye. Farmer, aye. Garrett, aye. Ogles, aye. Parkinson, no. Ramsey, aye. Chairman Russell, aye. You have 7 ayes and 1 no.
Thank you for that. We got a motion and a second on the bill. And Chairman Kumar, you are recognized. However, I do see actually 2 amendments. Which one would you like to run?
Thank you, Mr. Chairman. Amendment that we're running is 15486.
That's what I'm showing, 015486. Do we have a motion and a second on the amendment? We got a motion and a second. Chairman Kumar, you are recognized on the amendment.
Thank you, Mr. Chairman and committee, for this chance. I think this amendment corrects the matters that were expressed by the committee, and the concerns are addressed and corrected here. The idea of this bill is that with constitutional carry, we do not require citizens who purchase a firearm or gun to undergo gun safety course. Safety is very important. There are well-known examples, and even our dealers are concerned that people are not getting gun safety training. With that in mind, administration, who were very receptive and have decided to fund this effort. Initially, this was tied to gun purchase. Now, as expressed by members of this committee, that has been separated. At this time, there will be a sign placed at the gun dealership or flyer that basically informs citizens that gun safety training is important and is available, so they can go to any of the entities that provide gun safety training and have been approved by the Department of Safety. They can get their training. They're certified they did provide this training, and then they would be paid by the Department of Safety. The sign clearly states that gun safety training is available. State of Tennessee will pay $30 towards that effort. It also explains the cost to the person taking the training, because it's variable, because it may be $2 or $5 or $10 more. And under the sign, it provides the address of a facility and the contact information of a facility that is certified by the Department of Safety. And under the sign, it clearly states that gun purchase is not required. With that explanation, Mr. Chairman, I'm ready to answer any questions.
Thank you, Chairman Kumar. Representative Parkins, can we vote on the amendment to send it to the? Okay, so we're going to vote to add amendment. Okay, Representative Parkinson, you recognize.
Thank you, Mr. Chair, and thank you, Representative Kumar. The amendment does sound a lot better than what it was previously. Now, these signs, are these signs only going to be at gun dealerships, or will they be, how will the rest of the general public know that these gun safety classes are available and available to be paid for if they're not going into a gun dealership location?
Chairman Kumar.
The dealership can use flyers to inform general public, but beyond that, there is not particularly an ad campaign because of the costs involved. We want to use this money in a wise way, and we want to use it to provide safety training. And I think it will be a significant number of courses. We are talking literally about 100,000 of these courses being provided. And I think that's a very useful effort. I am aware and I remember your concerns about it, and I think we have addressed that concern the best we can.
Representative Parkinson.
Thank you, Mr. Chair. And just so I'm clear, so I can have it on the record, these gun safety classes, they will be available for anyone in the public that wants to receive them.
Chairman Kumar.
Thank you, Mr. Chairman. That is true, sir.
And last question, Mr. Chair, just for, so I can be clear on it. And thank you, Representative Kumar, for addressing my concerns. I truly appreciate it. And the cost of these classes are?
Chairman Kumar.
The sign says the state of Tennessee will pay $30. Underneath it says your cost, and that will be filled in depending on the entity providing the service.
Yes, sir. Thank you. Thank you, Chairman, Representative Kumar. I truly appreciate you addressing the concerns. Thank you so much. Thank you, Mr. Chair, and I'm in support of the bill, too.
Thank you. And we're going to vote to add Amendment 015486 to House Bill 2850. All those in favor signify by saying aye. Aye. Opposed, no. Ayes have it. Amendment's added. And Chairman Kumar, you are recognized.
Thank you, Mr. Chairman. Once again, I'm grateful to the committee. I think this was a good effort, and by working together, we made things better.
Thank you. And Representative Clemens, you're recognized.
Thank you, Mr. Chairman, and thank you, sponsor, and thank you, the committee, for reconsidering this bill. I think anything that is going to help facilitate handgun safety training, given the existing laws of the state and pending laws, is a good thing. The more people who are trained with handgun safety, the better. My questions stem from on the flyer that's going to be posted. It says the name of the entity providing the course. Who's going to choose which entity is listed on that sign? Is the state of Tennessee going to handpick certain private vendors or contractees? Or is it going to be the one closest geographically located to that firearms dealer? How's that going to be chosen?
Chairman Kumar.
The Department of Safety has a registration of entities that provide these courses, and those courses are those that have been approved by the Department of Safety. So yes, it will be one of the entities that is approved, so approved, and gives an approved course. And it would make common sense that it will be an entity that is nearby.
Representative Clemens.
Okay, and I want to make sure, I guess the firearms dealer, then you're saying, would choose which entity to list, or could they list multiple entities that are providing this training?
Chairman Kumar.
Yes, they can.
Okay. And does this have to be an in-person handgun safety course?
Chairman Kumar.
Yes, sir.
Okay.
Representative Clemens.
Thank you. Appreciate it, Mr. Chairman.
Representative Parkinson.
Thank you, Mr. Chair. So, and I'm still supporting the bill, but under the way it's drafted, it may be a situation where these dealerships are sending the traffic to the gun safety courses to their buddies, right? And can the general public use anyone that they want to use, or do they have to use who's on the sign of the location that they get?
Chairman Kumar.
They can choose anyone they want. They're not taking a copy of the sign or necessarily in that sense.
Okay. Thank you, sir.
Representative Parkinson.
Thank you, sir.
Thank
you, Mr.
you.
Chair.
And we're going to go out of session and hear from the Department of Safety on this. And Ms. Stroker, if you'll just do the normal, just turn your red light on 3 minutes and begin when you're ready.
This won't take 3 minutes. I promise I'll be quick. Elizabeth Stroker, Legislative Director for the Department of Safety. Thank you to Chairman Kumar. We've been in many phone calls, meetings, getting this right. We think it's, a great idea, but there are still some things we're going to work out in between now and as it travels, small things, date changes, making it a pilot program, cleaning up some of those questions specifically. We don't want people to name pick. We have, I think, 225 approved courses, so putting all of them on the poster would be difficult. So we're thinking changing maybe a link because we have it on our website. And so we don't have dealers sending it to just their friends or something. So we're still working on those details, getting everything right around how to reimburse and how that best looks. We're working with F&A. So just all that to say, we're still working on some language, but we've come to an agreement with Chairman Kumar, and he's working with us on it, just so y'all are not surprised when another amendment comes, that is something he's working on with us, and we appreciate the committee and Chairman working with us. But that is something we're going to address, is making sure it's not cherry-picking certain entities.
Thank you. Any questions for Ms. Stroker? Representative Ogles?
Thank you, Chairman. Thank you for being here today. How does this legislation commingle with I believe there was $500,000 that was earmarked for studying or putting up some pilot programs for firearm safety training for, I believe it was children. Can you speak to that money, what's being done with that money, and how, if at all, this will affect that or where we are with that other process?
Ms. Stroker.
Yes, and Representative Parkinson asked me this a couple weeks ago as well. This is separate from that endeavor. That endeavor, you're correct, is geared at school-age children and teaching them firearm safety when they come into contact with the firearm or how best to handle one, tell an adult, stay away from it, that type of thing. And we're working on that with TWRA, getting some videos together, material, so that we can go offer courses too, or not courses, but, informational training to children, working with them to do that. And so this would be separate for anyone who wants to take an actual course in person.
Representative Ogles.
Thank you, Chairman. And I may be out of order here, but I would like to just go ahead and make the plug to Department of Safety and the governor as well. The House passed a piece of legislation several years ago actually mandating safety training in all our schools. Every member of the House voted for that. And we've yet seen firearm safety training implemented in our K through 12 because of other hurdles from other organizations and other chambers. So I would love to see some legislation at some point from the governor or Department of Safety to combat this issue. And for all the gun lovers out there, training is just part of it. And it's something that if you're going to have that awesome responsibility and that awesome privilege and that awesome right that we all have to bear arms, training our young people is vitally important and just part of it. As parents and citizens and good neighbors, we look forward to expanding training in the state. So thank you for this legislation, and thank you for what great job you do in Department of Safety.
Ms. Stroker, okay, Representative Parkinson, you're recognized.
Thank you, Mr. Chairman. I'm so glad you got that extra set of eyes over there next to you, because thank you, Ben. Appreciate it. And Counselor, right now under the legislation, with the amount of money that's being allocated to this bill, how many of those $30 vouchers do we think will be given out, could be given out?
Ms. Stroker.
I don't know the exact number. I think Chairman Kumar mentioned somewhere around 100,000, but that was on the initial bill whenever it was tied to purchasing a firearm. This one we're not quite sure of. We know the amount of money that we can set aside for it, and so it'll just be that divided by 30. So whenever that runs out.
Okay, and Mr. Chair, thank you, thank you. And so I'm trying to see if we'd be better served in moving that $500,000 over to this bill also, and allowing the parents to take their children with them to these gun safety classes. We may be able to be better served and serve more people under that scenario, possibly.
Ms. Stroker.
I believe that money is already allocated and been spent for the children aspect of it with our department and TWRA. So I don't know if that would be an option at this point, since that was allocated a year ago, but certainly a good idea. If there's anything left, I can take that back to my team.
And last question, Mr. Chair. Thank you, sir. And Counselor, how are we ensuring that all schools get access to the gun safety courses under that $500,000?
Ms. Stroker.
It's optional. I believe that was kind of what Representative Ogles was alluding to, is that it is an optional for the schools and the teachers and the students. So if they want it, then we can offer that, and it would just be at that request.
Okay. Thank you, ma'am. Thank you, sir.
Thank you, and that's all the questions we have. Thank you for being here. We'll go back in session. Question's been called. We're voting on sending House Bill 2850 to civil full. All those in favor signify by saying aye. Opposed, no. Bill passes. Congratulations.
Thank you, Mr. Chairman. Truly, I'm grateful to you, committee members who had suggestions, as well as the Department of Safety. And it's a joint effort, and it's for a good thing. Thank you again.
Thank you, Chairman Kumar. Next up, item number 5, House Bill 2724 by Representative Miller. We have a motion or a second? Motion or a second? We got a motion and a second.
Thank you for the motion and the second. Thank you, Mr. Chairman, members of the committee. There's no movement in the Senate on this bill. So with that, Mr. Chairman, I'm going to withdraw House Bill 2724.
Okay, taken off notice. Okay, I understand because this bill has been calendared 3 times, it's referred to the special calendar to be published with a final calendar. So, thank you, Representative Miller. Next up, item number 6, House Joint Resolution 0760 by Representative Miller. We do have a motion and a second, and Representative Miller, you're recognized.
Thank you, Mr. Chairman, members of the committee. HJR 760. Let me first apologize to members of the committee because I haven't had an opportunity to speak to not one of you about this constitutional amendment. And of course, you know, constitutional amendments are uphill battle. It's a struggle. But if any member was interested that are lawyers for running for, let's say, a DA or judge, in this election cycle, if you're not on the ballot, then it would take another 8 years before you would be able to actually run for DA or for a judge. And that's something I'd never understood if you're talking about co-equal of government. For an example, every 2 years we have to go before the voters as legislators. Seems as if it's every year. Or, well, when you talk about the Senate every 4 years and then governor, that's a 4-year term, assuming that he wins re-election, and it's a term limit. And again, I'm thinking, what's the history of having judges and DAs with an 8-year term? I never could understand that, so do a little research so that we would not be so political. We know where that is today from the standpoint of DAs and judges being political. As we speak right now today, we're probably having one of the most, I guess, political hearings in the United States Senate as they decide whether to choose the first African-American female to the United States Supreme Court, which is a separate story. We'll go back to this. Again, my apology to you all. I haven't had an opportunity to speak to any members of the committee about this constitutional amendment. I want to withdraw this at this point because, again, it's a difficult thing to try to amend the Constitution, but I just wanted to kind of put this on the minds of at least this committee to give some thought to this because I very well may decide to bring it back again. And usually I'll think about it at least once a year, but this time it was 8 years ago that I kind of thought about this one. So with that, Mr. Chairman, pending any questions.
Representative Ogles, you're recognized.
Thank you, Chairman, to the sponsor. I think you're bringing up some great points, and I tried to reflect back as you were talking where I was 8 years ago. And it was nowhere near this building. And also the fact that, you know, as members of the General Assembly, we get up here and we go to work, and sometimes that reelection process, that every 2 years, you know, you really start to have to check yourself constantly as members of the General Assembly in the House, because you're always running for reelection every 2 years. We're always running, and the votes we make here affect our district. I am concerned that our judiciary is so insulated. That is a long time. That's almost a decade. To think you could run for the bench and be so insulated from your constituents 5, 6, 7 years out and not be held to many terms accountable for the decisions you make to your constituents and to the general public. So I think it raises a good question. At least it would be nice for a debate. And I see the lawyers looking at me from the other end, and that's exactly why we're here. So thank you for being a citizen legislator and bringing legislation that sometimes challenges the status quo and rethinks the system to the sponsor.
Thank you, Representative Ogles. Do you want to respond, or we got 2 more people? Okay, Representative Garrett.
Love to hear from the lawyers on the committee.
Thank you, Mr. Chairman. And you bring up an interesting point, but to play devil's advocate with you, with our DAs, with our judiciary, with our legislative branch, with our executive branch, there's 2 branches that are obviously political, right? There has to be. I mean, that's just kind of a known factor when someone serves a 2-year term or when someone serves a 4-year term. We're constantly running, right? I believe we all can say that we're constantly running. So on the flip side of that, with an 8-year term, you're not constantly running. You can concentrate on policy. You can concentrate on the judicial process. If we do change an 8-year term and make it shorter, then our DAs, then our judges will be running all the time. They'll be forced into the political arena and be political instead of being on policy. So I would just be careful of what you ask for to shorten a term, because then you're going to have our judges, our district attorneys doing mailers, doing ads, doing constantly making sure they are political instead of making sure we insulate that branch of government from politics as much as possible. And I do think while 8-year terms do seem a long time, but the judges that I appear in front of do not like the political process. We force them into it if they're going to be running like we are. We enjoy this process, I think, at least for the most part, because we're closer to our district. We're closer to the people. We are held accountable every 2 years of what we do and what we say down here. And so I would just say we want to be careful that I think that our judicial process, our judicial branch, is insulated from the political process. And I would rather them be that way, because I would rather them focus on the policies that we pass down here rather than being a political candidate. The shorter the terms, the more risk they become political. So that's all I like to say. So, but I do appreciate the legislation. I do think it's a worthy debate, but that's sort of my take on what we could be doing down the road, is making that branch a little bit more political. So thank you very much for bringing the legislation. I look forward to that debate in the future.
Thank you,
Mr.
Representative Garrett. Representative Parkinson.
Thank you, Mr. Chair, and that's why he's my attorney. And thank you, Chairman Miller, for bringing this legislation. And while they did raise some very valid points, maybe we should consider amending your legislation to make it so that we can run every 4 years versus every 2 years.
Thank
Thank
you.
you, Mr. Chair.
All right, we will be taking HJR 760 off notice.
Thank you, Mr. Chair.
Thank you, Representative Miller. Next up is item number 7, House Bill 2521 by Chairman Sexton. And I do show an amendment, but to even consider that amendment, we'll have to vote on just considering it since it's untimely filed. So all those, could you tell us the drafting code before I start doing that? Well, correction, we first need to get a motion and a second on the House Bill 2521. Do we have a motion or a second on 2521? We got a motion? No second. Bill dies.
Thank you.
And that brings us to our special calendar. So give me just. Okay, on the special calendar, item number 1, House Bill 1219, without objection, referred to the clerk's desk. Item number 2, House Bill 2724, without objection, referred to the clerk's desk. And that is it. Does anybody have any comments? Well, members, I appreciate the opportunity to be chairman this year. And Representative Garrett.
Thank you, Mr. Chairman. And I just wanted to express my gratitude for you, what you've done with this committee. You ruled with a great hand, and I really appreciate working with you on this committee. Looking forward, hopefully, to working with you again. So I just wanted to make that publicly known that I'm proud of you, and very, very, very good job, Mr. Chairman. Thank you.
Thank you, and Chairman Farmer.
Yeah, I want to say that I want to echo those thoughts and then go even beyond that. That it's being chair of the full committee. I was sitting in your seat just last year, and you've done a wonderful job. And subcommittee chairmen are so important because we're here to get to the bottom of things and not let bills out it's not good policy. And I think you've done a fantastic job of wrangling those bills in and letting the bills out that need to be let out into full committee. So it's made my job a lot easier. So I just wanted to thank you for that.
Thank you, Chairman Foreman. Representative Clemens.
Yeah, thank you, Mr. Chairman. To give this a bipartisan flair, I will say I have been incredibly impressed and thankful for your leadership on this committee. You have been incredibly fair. I think, to echo the sentiments of my colleagues to my left up here, we have dealt with some very tough legislation in this room this year. Either way you view it, this isn't an easy committee. We deal with some controversial stuff, and I think you have handled the gavel fairly and equitably, and I appreciate that. As a member of the superminority, that means a lot to me, makes my people I have the honor of representing feel heard and that they have a voice, and I greatly appreciate that. Thank you.
I appreciate you, Representative Clemens, and Representative Parkinson. You're recognized.
Thank you, Mr. Chair. And honestly, I want to thank you too for you've been a great chair. You really have. And one thing that's different about this committee is that you've taken this committee back to the old school. When I first got here in the plaza, where committees used to actually help to shape bills to make them better. This Chairman Kumar's bill is indicative of that. My bill that I had that actually got to the floor is indicative of that. And, you know, I hadn't seen that in a long time. And so I truly appreciate your leadership and all the members up here also. You know, criminal used to be my favorite committee. Civil is now my favorite committee. The only difference is you don't rule me out of order, and I kind of missed that. But right. But I really do. We get some really interesting legislation that comes through this committee, and that I think has tremendous effect on people's lives. And so I truly love being on this committee, and I appreciate your leadership on it. Thank you, sir.
Thank you,
And
Representative.
thank you, Ben, for recognizing me, because he never recognized me. Thank you, sir.
Thank you. All right, Representative Ogles.
Thank you, Chairman. I just want to thank you for the great job you've done. And it's surprising to say a committee is fun, but it's a joy to work with you as a chairman in this group of individuals that's on this committee. I learn something every time I walk into this chamber, and I'm impressed constantly by the talent of all its members. And just thank you for you, and thank you for all the members of this committee. You've made it a joy to come to work as a member of the General Assembly.
Thank you. And Chairman, you recognize Chairman Ramsey.
Thank you, Mr. Chairman. And I can't even squeak out the phrase that this is my favorite committee. This was way down on my list when we chose. However, you have made it my favorite committee just by your skill and your depth and perception. This is a lawyer-heavy committee. It's a place that I did not feel like I would fit, but I have fit very well because of your fair demeanor and your professionalism. So I thank you very much for 2 years of us coming together as a body and doing the work that the people requires. Thank you.
Thank you, Chairman Ramsey. Chairman Curcio, you're recognized.
Thank you, Mr. Chairman. And I've got to say, if you'd asked me a couple of years ago, who's going to follow Judge Carter, Andy Farmer, I'd say, I don't know, but it's going to be a tough job. You've done an excellent job. You've grown into the role tremendously. Been an honor working with you. And it's bittersweet for me because I'm not going to have another crack at this committee. So thank you for making it just a great experience.
Thank you. And I just want to say I appreciate each and every one of you all. Y'all are definitely the best of the best, and supercalifragilisticexpialidocious, if I had to say. But all right, seeing no more of business, we will be adjourned. And oh, absolutely, we do appreciate the staff, Ben, TJ, Michelle, and everybody here. Joel and our Sergeant at Arms. So without objection, we will be adjourned subject to the call of the chair. And closed subject to the call of the chair. I'll get this right someday.